Thank you, staff. Welcome, everyone. We're going to call this meeting to order now. It is 6:30 p.m. on January 30, 2023, and this is a public meeting of the City of Portland Police Accountability Commission Subcommittee on Officer Accountability. My name is Victoria, and I will be a facilitator today with Dr. Moses as well. Thank you. If the Spanish language interpreters, Luisa and Maria, can please give the information on the Spanish language interpretation. María o Luisa, ¿pueden interpretar lo que está en la pantalla o les gustaría que yo lo hiciera? Ok, entonces ya están en el canal de español. They're already in the Spanish language channel. Okay, I'm gonna interpret because we have to say it right now, but this is a public meeting. Esta es una junta pública que está sujeta a la ley de Oregon y a la ciudad de Portland, las reglas administrativas, y se va a grabar. El lenguaje en español, la interpretación está disponible para esta junta. Cuando usted necesite tener acceso al lenguaje de español, a la interpretación, usted puede ver un video feed para de las personas que están hablando. Y el audio y el sonido también va a ser reemplazado por las personas que están interpretando. Para tener acceso a esto, por favor, haga un clic donde dice lenguaje interpretation en la junta de Zoom, en los controles que están abajo en su pantalla y seleccione español. Thank you. The city also offers ASL interpretation, which is being provided by Andrea and Jill. Thank you. Please pin the video feed to see their interpretation throughout the meeting. The closed captioning is turned on in Zoom as another means of assistance. But please note that this is an automatic captioning service and it is not always accurate. The city supports access to meetings of the Police Accountability Commission and can provide other language support as well. Please email in advance of future public meetings, either as a response to a public meeting notice or directly to policeaccountability@portlandoregon.gov to ask for other access assistance, including interpretation into other languages. This meeting is a public meeting subject to City of Portland Administrative Code and Oregon State Law and is being recorded. For this meeting, the chat function is enabled for commission and members to communicate with each other. Members of the public will be able to ask questions using Zoom's Q&A feature as the commissioners are presenting and or discussing things. If attendees have questions, please feel free to submit them through the Q&A. We hope to use this feature to help guide our conversation during the meeting and future meetings agenda topics. We'd like to be clear that not all questions will be answered during the meeting, but if answered, both that question and answer will be visible to you and will become part of the meeting record. To access this feature, just click the Q&A icon in the middle of your screen. Now I will pass it to the co-chairs for the land acknowledgement.
Thank you. Charlie Michelle Wesley, co-chair of this phase. The PAC currently uses the land acknowledgement on display at City Hall. I have asked my co-chair Dan Handelman to present the land acknowledgement.
Thank you. Yes, I am Dan Handelman. I use he, him pronouns. And I keep prefacing this by saying if I were to make my own land acknowledgement, it would be stronger than this, but this is what the city says. We acknowledge that the rivers, lakes, streams, and lands of the lower Willamette River rest upon the occupied territories of the Multnomah, Wasco, Cowlitz, Calumet, Clackamas, Chinook, Tualatin, Kalapuya, Molalla, and many other tribes. We recognize the many villages, traditions, cultures, and relationships that existed along the river since time immemorial. We recognize these tribes stewarded these lands and rivers since time immemorial for future generations. We recognize and undertake responsibility for the destruction of the river and land, of traditional food sources, sacred places, and multifaceted ways of life. We acknowledge the economic and social values that enabled the harm to the river, including systemic racism, classism, and other systems of oppression that perpetuated harm against Black, Indigenous, and immigrant communities along the river. With this acknowledgement, we commit to honoring and learning from the past and working towards a more equitable and sustainable future for the lower Willamette River. We commit to seeking solutions that acknowledge the inequities of past socioeconomic policies and the harm done to people and our relationships to these lands and waters.
Thank you, Co-Chair Dan. Now we will move to our community agreements that we review in every meeting. These community agreements are in 3 different pages. What we're gonna do is read it silently, and then I will ask this question. Please go to the next. Thank you. Thank you. Go to the next. Now, I would like to ask everyone, do we all commit to following the community agreements for today's meeting and to gently calling in our colleagues and collaborators if needed? Can I see your hands? Thank you. We really appreciate it. Thank you very much. I will pass it to the co-chairs to discuss the timeline and other agenda materials.
Thank you. Okay, I will cover these next few slides for you. Police Accountability Timeline. This meeting is a part of the Police Accountability Commission's Powers and Duties phase of work, which focuses on the functions of the new system. Future phases of work will develop the form of the new system, as well as how it relates to the rest of the city government, and the transition plan from our current system to the new one. The Commission will present all proposed changes to the City Council in 2023 for their consideration and approval. Next slide. This slide shows the outcome documents for the Powers and Duties phase, based on the agenda and scope approved by the Commission. This subcommittee focuses on the processes the new oversight board and agency will use to address administrative officer misconduct, complaints, investigations, findings, discipline, and more. Okay, this slide is the current project plan for the Powers and Duties phase of Police Accountability Commission's work. It will be updated as needed throughout the phase of work. This slide is for members of the public to be able to understand how the commission gets from now through the end of the phase, which focuses on identifying areas of agreement among commission members as to the functions of the new system. Today's meeting is part of the green box with the red border near the bottom of the screen. Okay. Following today, here are the upcoming meetings of the Police Accountability Commission. Specifically, we'd like to highlight the commission is planning a community listening session and Q&A for tomorrow, Tuesday, January 31st, which will be held over Zoom. This subcommittee meets one more time on Thursday, February 2nd. The full commission meets next Monday, February 6th. And when they're talking about the subcommittee, that's on officer accountability. The full commission meets next Monday, February 6th, and the next Thursday, February 9th, and may conclude the powers and duties phase of work during these two meetings. And it doesn't say that, but the community planning, community listening is 6:30 to 8:30. Okay. Review of today's meeting's purpose. Today's meeting agenda includes working through the updated co-chair's draft of the areas of agreement on officer accountability, flagging items. Sorry, one moment, please. For further discussion, resolving items and possibly referring the document to the full Police Accountability Commission for their consideration next week. The subcommittee will also hear public comment during today's meeting. Okay. Draft the Police Accountability Commission areas of agreement on officer accountability. Co-chairs walk through a draft revision. We're now going to start discussing the draft Police Accountability Commission areas of agreement on officer accountability, which the subcommittee is tasked with. Oops, that's not my part to read.
It's okay, Co-Chair Shirley, you did wonderful. Thank you.
You could finish that sentence.
Okay, which the subcommittee is tasked with referring to the full commission for its approval. I will pass it to Co-Chair Charlie and Dan to explain any updates to the document.
Hi, thank you. This is Dan Handelman again, and there's a lot more people in the audience than the last time it was highlighted by the staff and chat. I just want to say thank you to everybody for coming today. In case you haven't been to one before, this subcommittee is charged with discussing what is going to happen to a complaint from the time it comes in the door or when the incident occurs, all the way to the time an officer may or may not be disciplined. So we've been talking about an outline that will talk about the various routes that might take, and we had a 4-hour meeting on the 21st, on Saturday the 21st, to get through as much as we could. There are 6 subsections of our draft, and we got through the first 4. So today we're going to go, well, take a little side trip, and then we're going to get through the last 2, I hope. And if we're lucky, there's a couple other things we're going to take care of at the end. Co-Chair Michelle Wesley and I went through sections D, E, and F, the 2 that we're doing today, and added the footnotes in there. So now every section and every subsection, we hope, has some kind of footnote on it, so you know where the information came from that we are proposing to the full commission, and then hopefully eventually to City Council. We also have this lovely flow chart that Commissioner Faith Aiken put together for us that she's not part of the subcommittee, and I would just want to quickly walk through that to ground people both on the subcommittee and in the public who aren't familiar with what we're doing. If staff, if you can pull up that flow chart. Thank you. So this first slide shows the very first point is the incident that happens between the Portland Police and a community member. And then from that point forward, either a complaint happens or there may actually be an investigation without a complaint. For instance, if there's a deadly force incident, that's one of the things that's required by the charter that we're trying to flesh out here, and that would happen anyway. So either way, there's going to be an investigation, a preliminary investigation to see what happens. A complaint could be dismissed, go to mediation, or go to a supervisor in some cases, not in deadly force cases, and then be referred to full investigation. So let's go to the next slide. And we're working out some details on this one, but there'd be some kind of internal body. It says internal affairs here, maybe something else inside the city, but that would deal with officer and officer complaints, but the officer may also choose to complain against another officer to the board. Okay, next. Then the full investigation on the person. Oh, if there is a complainant, that is to say a person who either filed a complaint or is the subject of misconduct, they would be assigned an advocate by the board to help them walk through this very complicated system. There'd be a full investigation. There'd be that could end up leading to a criminal investigation being dismissed or going forward to a hearings panel that we're envisioning. So this next slide. And the hearings panel would hold a hearing, first preliminary hearing to make sure all the investigative materials are needed. Then they hold the full hearing, and either they substantiate one or more allegation and head to the discipline process, or there might be an appeal if one of the parties agrees to that. We'll have to do more work on this flow chart. Okay, next. So this is what the appeals would look like. That's 3 possible outcomes where the panel agrees with the original findings. They send it back for more investigation. They make new findings. And if there's any substantiated findings, they go to the discipline process, which I hope is the next and last slide. The discipline process, if the officer accepts the discipline at the end of the process, otherwise the officer has a couple of routes to appeal, including the same appeal process as a community member, going to the Civil Service Board, going to arbitration by filing a grievance, or having a due process hearing. So that's a very complicated thing we're going to talk about tonight. So that's the outline. Thank you.
Thank you, Co-Chair Dan. Now we will move into discussing the draft areas of agreement on officer accountability. This will include reviewing the document, which has had some updates to the text based on previous documents. It will also include revisiting items flagged for further discussion in advance of the decision to refer. We ask you to follow our normal discussion rules. Please be brief each time you speak, even though you can speak multiple times. Please be facilitated, and remember that now we use a weighted stack in our discussions. And finally, please be forward-looking in your comments. Will the co-chairs like to get the discussion started? Okay, thank you. I will pass it to the co-chairs.
You're muted, Dan.
You're still muted, Commissioner Dan.
I don't know how that happened. I did not mute myself. How did that happen? Okay, so I forgot to mention that before we get into sections E and F, we're doubling back to the beginning of the first half of the 2 documents that we have split this outline into, to fix a mistake, a very crucial mistake that I made by copying and pasting badly. So if you look down at A6B13, it's 12 and 13. A6B12 is harassment, A6B13 is intimidation. And then we're talking about adding, this was staff's proposed way to deal with the numbering for the time being, A6B13.5 is retaliation, which was mentioned in 2 other cities, Denver and San Diego County, or jurisdictions. It's also a very important part of the DOJ agreement here in Portland. It's one of those things that's really important, and we want it to be one of the automatic investigations that would happen. So I guess we're going to ask the facilitator to ask the subcommittee if there's any opposition to that.
Okay, thank you, Co-Chair Dan. And what I will say is there a strong opposition to changing from what it was to the proposed change? is there agreement to changing from as was and to the proposed change? And I will ask you to hold your hands when you vote. That way the video can capture that. Thank you.
Okay, great. So then I guess we'll proceed on to E1, which is also mine. So that's in the second document. I think the staff is just noting that we did this. Excellent. E1, new options, magnify. Okay. So this is a section on appeals. We haven't discussed this in any of our meetings to date, so that's why it says discuss in full at the top. And the staff is adding space for technical reasons. Don't worry about it. So pay no attention to the man behind the curtain. All right, so E1 is both the complainant and the officer have rights to appeal their cases. And then E1A, the sub-thought to that, the first sub-thought to that is the complainant may appeal findings, dismissals, or decisions not to investigate. Any discussion or questions about that? The E1 was generally agreed upon in the research phase, and then E1A is an explanation of the complainant's possible ways to appeal.
And my question will be, can we move on to the next? Because there are not 6 changes. So, there is something in the chat. Let me see.
That's just an explanation of those extra lines.
Oh, okay, thank you.
So
Thank
I can only see 3 of the 5 commissioners on my screen. So is everybody saying they're okay with that? Those first 2, yeah, okay.
Okay, we can move on to the next.
I'm going to read all the parts of E1B together. So E1B, police officers may also appeal findings, dismissals, or decisions not to investigate. I'll come back to that in a second. Supervisors cannot file appeals on behalf of officers, and officers may alternately file appeals with the Civil Service Board, which was discussed later in another section, or initiate a grievance procedure, which may lead to arbitration, which is also discussed in the further section. And at first, I questioned why would an officer appeal a decision not to investigate or a dismissal, and the answer might be if they are the complainant. If it's the police officer complainant against another officer and it gets dismissed, they might want to file, they might want to appeal that. So,
any discussion or questions about this section?
You're not seeing any?
Okay, can we move to the next one?
Okay, E1C.
Let me wait because I didn't see Commissioner Catherine. Do you want to have a question about this, or you want, it's okay to move to the next one? Okay, thank you.
Thank you, Facilitator Lara. Okay, E1C, I'm going to read this, the main one and the subpoint number 2 instead, even though there's only one of them. The E1C, the request for an appeal will include the name of the complaint. Oh, I see. We didn't renumber it. Maybe. All right. Anyway, so E1C, the request for an appeal will include the name of the complainant or officer filing, date of the incident, and the reason for the appeal. And E1C1, I think it is, the advocate provided by the board shall assist the complainant in filing the appeal form.
Thank you. Do we have any questions or discussion about this item? No? Can we move on? Okay, to the next one. Thank you.
E1D, and I wrote this as a discuss, we wrote this in big discuss letters. The board has independent authority to reopen cases when it is in the public interest. Reasons may be due to written, verbal, or other community opposition to a decision. And I'm going to read E1D1 and we can discuss this. E1D1, suggestions for the board to reconsider a case may be made by a vote of City Council. So the explanation of this is that, well, first of all, it came from another jurisdiction, San Diego County and New York, other jurisdictions, plural. And we had run into this question of what's the proper role for City Council in this system. And even though currently the ultimate appeal can go to City Council to vote on a finding, I think that we felt from our discussions as a subcommittee and perhaps with other members of the commission that the city council's role should be more limited. And in this case, they would be able to say, we would like you to reopen this case, and then the board still gets to decide whether they want to reopen it or not. So that's what E1 D1 is. And it's sort of what happens in San Diego County, although they have the authority to tell them to do it in San Diego County. So we were turning it into a suggestion here.
Thank you, Co-Chair Dan. Are there questions, comments, or discussion about this item? Yes, Commissioner Debbie?
So I think I may have missed what you said. So are you saying that, I see the majority is striked out, it has been stricken out, I should say. So can you explain that?
Well, we've been running into this problem a lot with, we don't want to dictate what the voting type will be, and we don't know what city council is going to voting decisions are going to be like when the charter kicks in 2025. So instead of saying, just say by a vote of city council.
Okay, thanks for the explanation.
Thank you, Commissioner Debbie and Co-Chair Dan. Besides that, any additional comment or discussion? Okay, yes, Commissioner Catherine?
Yeah, this is not directly on this particular item, but I've been thinking about this since you went through the flow chart again. And I think I had not picked up or focused on the fact that at least according to this flow chart and according to what we're going through here, it seems like the appeal right is from the finding that misconduct has been substantiated, but does not include the ability to appeal the discipline imposed at the same time. So it looks like based on our flow chart, there's a finding that's substantiated, and an officer, let's just say we're in that context, the officer could appeal the finding that misconduct was substantiated, but that discipline would not occur until later, which means that the discipline would not be included in that appeal process. That's the question I have in terms of the flow chart and what's contemplated here.
Thank you, Commissioner Catherine. Co-Chair Dan?
Okay, Commissioner McDowell, thank you for that question. And when we get into the flow of what the rest of the appeals will be, I think that'll become a little clearer. But necessarily, if a substantiated finding or an out of policy finding is going to be overturned, then the discipline will go away. So if you're saying that can the officer appeal, they can agree with the substantiated finding but appeal the discipline, I think that's what the due process hearing is about, and we'll talk about that when we get to that part of the flow chart. I mean, the outline.
Why would we have a different appeal process for the misconduct finding and the imposition of discipline? Why wouldn't somebody be able to appeal both of those at the same time to the same place?
Well, so I'm not sure if we're talking across each other, but if an officer is filing an appeal about the finding, then and the board agrees, then there's no discipline anyway. So they're necessarily appealing both the finding and the discipline at the same time.
But what happens if the finding is affirmed on appeal, but the officer wants to say, fair enough, but I don't agree with the discipline?
Well, again, that's where the due process hearing comes in, because the community member doesn't have discipline on them, and there's no other level of appeal for them at that point. So the officer has rights that are given to them by the gods of the law that are we can't change, and they already have that built in where they can appeal that in a separate way.
Okay.
Instead of making the board go through 3 hearings, essentially.
All right.
Well, I take that back. So you'll see why I say that when we get to it. Okay.
Got it.
Are you all right with that then?
Thank you. Any additional discussion? Then can we move to the next one?
Yeah.
I don't see it. Okay, then let's move to the next one.
All right, so this is my last one for this section before I turn it back to my co-chair. E1E, a request to end an appeal may be made at any time, but withdrawal should be done in consultation with the advocate and may include confidential information. If practical and appropriate, the appeal might still proceed without the complainant. So this is adapted from Portland City Code. Yeah, and so basically we're giving the board, in the previous section, we gave the board the authority to reopen a case when it's in the public interest. So if the complainant wants to withdraw for their own reasons that they don't have to say publicly necessarily, but the board thinks it's really important to go ahead with the issues that were raised upon the appeal, then they should have the ability to do that if they want to. That's what this paragraph's about.
Thank you. Are there any questions, comments? Okay, I don't see any. Then can we move to the next one, to E2? Okay, thank you.
Thank you, Victoria. Charlie Michelle Wesley, co-chair. I'm going to do the E2 timelines for appeals. E2A, community members have 30 days to appeal, but exceptions can be made to extend the timeline. Should I read the two bottom ones into this first before we go to discussion?
Yes. Well, I mean, I don't know. You decide, but it's part of it.
Yes, I think you should do all of E2A together on.
Okay. So E1A1, the board may adopt rules for permitting late filings, including but not limited to. Is that numero uno? Roman numeral 1A, no, one. Oh man, there's too many characters here.
Michelle, so
Yeah.
there's a typo in the numbers anyway. So you're looking at E2A1, E2A1, Roman numeral 1, and E2A1, Roman numeral 2.
Oh yeah, there's a couple there.
Say E2. Yeah, thanks.
All right, I'm fixing those now. Okay, let's start over. E2A1, the board may adopt rules for permitting late filings, including but not limited to. E2A1, I'm just going to call it I, it's easier. The complainant has limited English language proficiency, E2A1, two I's. The complainant has physical, mental, or educational issues that contribute to an untimely request for review.
Thank you, Co-Chair Charlie. Is there any questions or comments? Yeah, Commissioner Catherine?
No, I think just to balance the considerations here of being allowing exceptions for good cause, but then also wanting to have finality and some a timeline that allows this process to be completed in a reasonable time span. I think we should say have some outside limit, that you can permit late filings, but in any event, no longer than 60 days or something like that. So that this isn't just allow someone to come in really at a much later time period and try to appeal. I don't think that's fair to the other participants. And I think it creates a pretty messy process unless I feel like there has to be some cutoff. It's, fair to say 30 days might be a little tough for some people, but I think there should be an outside limit.
Thank you, Commissioner Catherine. And how do you suggest that addition to be written?
I would say something like the board may adopt rules for permitting late filings up to 60 days for reasons including but not limited to, or something like that.
Thank you.
I'm not stuck on 60 days, but I do feel like that is, you know, in my world, 60 days is pretty much the outside time period for an appeal. 30 days or, you know, at the most 60 days. So I'm not sure it's unreasonable to say that even in situations where good cause is shown that you should have more than 60 days to appeal.
Thank you. Is there comments or preference on the number of the days? Any suggestions? Yes, Commissioner Christian?
Just curious, the 60 days, is there a reason that's generally used for the limit, the like cap limit on appeals? Do you know?
So I think it's, you know, people are looking for, I think setting kind of general expectations. And I would say that 30 days is often the appeal time period. In the administrative world, it tends to be 60 days is the limit. And I would say that it is really unusual to find any appeal right that's open-ended. You know, it's usually, you know, it's a pretty hard and fast rule. So I think 30 days with the ability to extend it to 60 is actually a pretty, you know, good standard. It moves the process along, but allows some ability to take the longer period. So you know, why 60 days? I think it's really just giving people enough time to figure it out, but not so much time that it drags on the process and makes it unfair for the other parties involved.
Okay, cool. Thank you. Yeah, I don't have much experience with it, so I wasn't sure if there had been like research done on that, or it was just kind of a number that pops up. Thank you.
Thank you, Commissioner Christian and Commissioner Catherine. Is there an additional discussion question? Okay, then can we, oh, I need to ask the other question. Is there a strong opposition to changing from as it was to the new proposed change of adding up to 60 days for reasons? Is there an agreement to changing from as it was to proposed change adding the 60 days phrase? Thank you. Can we move on to the next one? Okay.
Okay. E2B, the timeline for officers to appeal is 30 days, with only limited exceptions if they are incapacitated or unable to receive or send information to the board. Should I read the E2C as well?
Yes, please.
Until the appeal period has expired, and if an appeal is filed, until there is a final decision by the board, the city may not enact proposed discipline.
Thank you, Co-Chair Charlie. Is there a comment, discussion, questions? Yes, Commissioner Catherine?
So this is in response to a staff question, and I think relates to this, which is the 60 days, I think, should also apply to where we say with limited exceptions, allowing up to 60 days if they are incapacitated or unable to receive or send information to the board. So similarly setting an outside timeline for appeals to be brought.
Thank you, Commissioner Catherine. Is there any other comment? Okay, let me ask the question. Is there a strong opposition to changing from as it was to the proposed change? Is there an agreement to changing from as it was to the proposed change? Okay, thank you very much. Can we move on? Okay, let's go on.
Okay, so now it's going to be E3, which strap yourselves in because we go through letter J on this. So it's going to take a little while, but we'll be okay. We're good, doing good. All right, appeals hearings, E3. E3A, and I'm going to read through the whole E3A. Appeals will be heard by a different panel of board members than heard the original complaint, except in cases in which the basis for the appeal is the presence of new information. In either situation, this will be referred to as an appeals panel. E3A1. A certain number of board members will be assigned to a board appeals committee whose main function is to hear appeals, and that's a big one we're going to come back and discuss. E3A2. If a member of the original panel is unavailable, a board member or appeals committee member who is not part of the original hearing may be assigned to the hearing. And E3A3, if there are not enough members of the appeals committee for a quorum, members of the full board who did not hear the original case may be assigned to the hearing. Okay, so I'm just going to wrap back to the top. So the whole concept of appealing to the same people who already heard your case just seems to be not making any sense. So, but if those people already have all the background and all they're doing is hearing new information that's brought in by the person who's appealing, then it makes sense that maybe that they can save a lot of time in the whole system if all they're doing is reconsidering the basic facts plus this new information. So that's the idea of having the same people only hear it if there's new information. This idea of having, like, so, you know, we're kind of already picturing kind of a relatively large board in order to have enough people to hold all these hearings, especially if they're going to be volunteers, which we don't know. But the idea of having an assigned set of those people who don't have to go necessarily hear these lower level hearings every week or every month or however often it's going to be, and having a specific group of people, specialty is the appeals, is kind of built on the idea of the current Citizen Review Committee. It was just something we put in for discussion, but you know, I'm anxious to hear what other people think about that.
Thank you, Co-Chair Dan. Is there questions, opinions, or comments about this part? I don't see any comment or question. Oh yes, Commissioner Catherine, please.
Yeah, I guess in another way to address new information is to allow a participant to ask for rehearing of the you know, original fact-finding process, and that typically is more would be the more expected process, that the appeal is based on a closed record of the information that was presented to the hearings board, so that you know, this contemplates that you could bring in new information in the appeal process, and typically that's not allowed. Typically the appeal would be based on the record that was made in the hearings process. And so if you have new information, people would typically go back to the hearings process and seek rehearing, seek a new hearing, seek to reopen the hearing, or in some way seek reconsideration, and then present that evidence to the hearings panel. They would not appeal on the basis that there's new information and try to present it to the appeals panel, if that makes sense. So I'm not sure. I agree with the fundamentals here that the appeals panel should be different than the hearings panel, but I guess what I just want to say, what's implied here, that an appellant could produce new information on appeal, that's typically not how it would work, and that might be inconsistent with the due process guarantees that we talked about earlier, where the decision is based on a record and the record is made in front of the hearings panel. Does that make sense to people? I know it's kind of a technical issue, but that's my comment. Thank you.
Thank you, Co-Chair Dan.
Yeah, well, I hear what you're saying. I guess you're talking about administrative hearings that you're used to, and maybe the term appeal isn't the exact right term of art here. This is one of the problems we've had throughout the years with the current system and the Citizen Review Committee, is that people think of this as an appeal like when you're going to an appeals court, but it's not. In the current system, there is no lower court. There is no community body that has heard the case. So for the sake of clarity and trying to keep down confusion from community members, I thought that using the word appeal to apply to either kind of next level hearing would be easier than trying to call it two different things. I understand exactly what you're saying, and that's why we have it bifurcated this way, that if they bring back something new to the original panel, then they have a hearing about that. But if they are just saying, I disagree with what you said, they go to a different people. And it seems kind of clunky if we call those two different things, I think.
Thank you,
Are you implying that there's a legal definition of appeal that's going to cause a problem? Because this is, again, remember, this is an administrative process and not a legal one.
I guess what I'm saying is that the due process requirement requires a decision to be based on a record. And typically that record would be heard before a hearings panel, and then the appeals process would be based on that record. That's usually the way the due process guarantees work, that you've created your record in front of a hearings panel where people produce their evidence, and then the appeal is based on that record, and you can't bring new things into that record. Otherwise, you violate that due process principle because you're pulling from things that were not before the hearings panel. So it's a little bit hard to say the hearings panel wasn't reasonable when the hearings panel didn't have all of the evidence. So typically what would happen is that hearings panel would rehear the case with that evidence. So that's what I'm pointing out, that would be, I think, what people would expect here, that if new evidence is found, that you would ask for the hearing to be, recreated so that you could then present that evidence and create your record. So that's all. I don't want to get too technical, but I'm just making that point to try to ensure that we tend to the due process piece along the way.
Thank you, Commissioner Catherine. I will pass it to Co-Chair Charlie.
Okay, so there is, and I don't know if this is okay, but there is a comment in regards to this from Yume Delgado. Should I read that?
Yes, please.
Given your section on holding proposed discipline until the appeal window is closed, you might want to have a mechanism where you can affirm that there will not be an appeal. Both parties have accepted the finding or waived their right to appeal. Does that fit in here?
Yeah, no, it's actually something we're going to address later. So I actually answered the co-chair of CRC Delgado posted that in two parts, and I answered that and said we'll get to
okay.
later.
I want to make sure.
Yes, thank you.
Iona, and then I'll get back to
Thank you, Co-Chair Charlie. Thank you. And Commissioner Debbie?
So if the understanding of what appeal means is that you're re-looking at exactly the same information a second time, and to ask the question, did you make the wrong decision? But at least in the system we have now, when you come to what they call appeals hearings, you're allowed to bring new information. So would it make sense to change the name then so people could bring more information if they wanted, and maybe call it reconsideration or something like that? I don't know, I'm just throwing out an idea of trying to get around this, still allowing people to bring something new if they have it to the appeal hearing. The one thing that's different though between now, what our new system will be and what we have now is the actual evidentiary hearing will be in the open. And so now, all of that is done, kind of behind closed doors, and then it comes to the out into the public. So I don't know how that changes things, and I'm just throwing ideas out here. I'm sorry, I don't have the answer, just some thoughts.
Thank you, Commissioner Debbie. And we also can flag it for later, but let's hear from Co-Chair Dan.
Yeah, okay. I have a proposal about how to deal with, well, at least the new information question. So this doesn't say that they bring the new information to the hearing. This says that they're bringing new information when they file their appeal. So I think what we should do is add in an E3A4 in the case that an appeal is based on the introduction of new evidence, board investigators will confirm the validity of the evidence prior to an appeal hearing moving forward. I don't know if validity is the right word, but you know what I mean. So it's kind of like what we said before about, you know, you can't just bring something in and say, you know, to the hearing and say this is part of the case. You have to send it back for more investigation first. So that's my proposal about how to deal with that. Does that work for folks?
Thank you. Is that Commissioner Catherine, that helps? Or do you have any additional suggestions of wording, use of words on this statement?
No, I think that gets at one of the concerns I had here. So, and I'm fine to just keep moving on. I've made my point, and you know, I just, you know, this certainly being able to have some verification of the evidence that's being presented, if in fact then the decision is going to be based on that, then I think that gets you closer to meeting those due process standards that I was concerned about. So
Thank you. Okay, then I will be asking, is there a strong opposition to changing and adding E3A4? Is there a general agreement to changing from to adding A3A4? Is there general agreement? Okay, thank you. Can we move on to the next one? Thank you.
All right, so E3B, and I'm watching my life slip away from me. So this is another issue, but I'm going to preface this with, I think, the footnote about the Civil Service Board, which is defined in the city charter. There's a 3-person panel called the Civil Service Board. I've never experienced anything where this came into play, but it exists. And all city employees have the right to use this board if they've been had discipline proposed to them. So here's the point, E3B. If an officer chooses to appeal to the City Civil Service Board, the review board panel shall receive a copy of the appeal and provide a written statement about the misconduct and supporting evidence. And E3B1 says, one or more review board members may attend the Civil Service Board hearing, subpoena witnesses, present evidence, and cross-examine. And this all comes from another jurisdiction. It's very hard to see what that says. Oh, San Diego County. Thank you.
Thank you, Coach Jordan. Is there a comment, question, or discussion? And E3B and E3B1? Can we move on? Okay, sorry. I will ask Commissioner Christian. Go ahead, Commissioner.
Thank you. I was just curious. I may have missed something earlier, but the sentence, the way this is phrased weirdly to me implies that do they not receive a copy of the appeal and private written statement when a complainant does it? Why is this specific to when an officer uses the system or the a process or whatever?
Thank you.
This Civil Service Board is not open to the community member appealing there.
Oh, sorry. Yeah, so I did miss that. Thank you. Okay, cool. Sorry. Thank you. That was all.
Thank you. And before I pass it to staff, I will pass it to Commissioner Catherine.
Thank you. I've gotten confused about who the review board is. The review board, the appeals committee.
It says the review board panel. So yeah, I mean, yes, this would be the appeals panel, not the review. Well, no, No, because if the officer chooses to appeal to the city service board, the review board panel, so this is the hearings panel from the earlier section on hearings that we did at a previous meeting. So it should probably say the hearings panel, but
Okay,
I'm thinking, Commissioner McDowell, about a case where there's an appeal. I mean, I don't know legally, and this may be something we have to throw into the city attorney's long, what do you call it, garden plot, whether legally they could appeal to the board and then also appeal to the civil service board. I think they have to choose one or the other. That's what the contract currently basically implies, the PPA contract, that they have to choose how they're going to file their appeals. They can only do one, they can only take one route.
okay, thank you.
Thank you, Koshertan. Is the staff? No, doesn't wanna.
The same question that Commissioner McDowell had, so no need to ask it a second time.
Okay, thank you. Then is there additional discussion, comments? Okay, is there a strong opposition to changing from as it was to the proposed change? Is there general agreement to changing from as it was to the proposed change? Okay, thank you. Can we move on to next one?
We can't, you know, if we had this flagged already for a bin item for the city attorney's garden plot, we should also say whether it would require a change to the city charter to allow the board to participate in these hearings, because the civil service board is part of the, it's written into the charter. We're writing this and hoping that that isn't necessary, but you never know.
Thank you, Kosherdan, and the staff is putting on the garden plot. Thank you. Okay,
All right,
let's go to the next one.
3C. And then I know when we want to take a break, because we're not, I don't think we're gonna get to J in a reasonable amount of time, but we'll get as far as we can. You just let me know, Facilitator Laura, okay?
Sure.
All right, E3C, another discussion point. If an officer chooses to file a grievance and an arbitration hearing is held, the review board panel shall receive a copy of the grievance and provide a written statement about the misconduct and supporting evidence. E3C1, the review board may have one or more representatives attend the arbitration hearing to present evidence and answer questions about the findings. This also is something that is contemplated in a jurisdiction that's hiding from my vision.
Do you want to continue or?
San Diego County, thank you.
Yes. Okay, there are any questions or comments about E3C and E3C1? Okay, Commissioner Catherine?
Just that, I think the review board again should be changed to the hearings board. Is that what we called it earlier?
Hearings panel.
Hearings panel, thank you.
Okay, that's a good idea.
Thank you, Commissioner Catherine. Then I will ask the question, is there a strong opposition to changing from as it was to the proposed change? Is there a general agreement to changing from what it was to the proposed change? Thank you. Can we move to the next one?
Commissioner Dan, you are, I think, muted.
Oh,
Oh,
yes.
I was wondering if Commissioner McDowell was thinking about something. Are you ready to move on?
Yes, I am. Sorry if I
Okay.
didn't.
E3D. To the extent possible, the complainant will be allowed to attend or at least remain apprised of appeals held outside the board's direct scope of authority with their advocate assigned until a final decision is made.
Thank you, Co-Chair Dan. Is there a comment, questions about E3D? Okay, can we move on? Thank you. Let's do E3E.
E3E, at an appeal hearing, decisions on the findings shall be made on the preponderance of the evidence. And I'd like to cite the footnote there, from San Diego County and subject matter experts, Eileen Luna Firebaugh.
Thank you, Co-Chair Dan. Is there a comment, question about E3E? Can we move on? Okay. Let's do E3F.
Okay, E3F, all members of the appeals panel shall review recordings and other records of the original hearing.
Is there a questions or comments about E3F? Can we move on? Okay. E3G.
E3G, appeals hearings shall follow the same procedure described in the findings section on hearings, including for disciplinary decisions. The panel may expedite matters by not repeating information already in the record. And then E3G1 says, at the start of the hearing, the basic circumstances of the case, allegations, and original findings shall be read into the record. E3G2, at the end of the hearing, the appeals panel may vote, and then there's options E32G, Roman numeral 1, to recommend further investigation, or E3G2, Roman numeral 2, to affirm the original findings, after which the board staff shall close the complaint based on those findings, or E3G2, Roman numeral 3, to determine a different finding based on the evidence and make disciplinary decisions if there are findings that the officer violated policy.
Thank you, Co-Chair Dan. Are there any questions or comments? Commissioner Catherine, do you have a comment?
Yeah, I'm still trying to understand now how we're dealing with discipline here, because we were talking about the fact that the discipline would not be imposed. That the appeal would not be from the disciplinary process. I'm just kind of confused about what we're talking about in terms of how the discipline is working and where the appeal of the discipline is coming from.
All right, so it's sort of, maybe we might need to put this explicitly in our outline, but it just seems to confuse things more. But maybe the more we confuse ourselves, the more better off we are putting more things in. But here's the thing. So if the appeal comes from an officer about a finding of a policy violation, and the board again decides there is a policy violation, they have to re-vote on the discipline, or else they're affirming their earlier finding about discipline, right? But if the appeal is based on something that came from the complainant, then they're going to be, so that would be E3G2 sub 2, and sub 3 is if the complainant appealed it, or if the complainant is an officer that's against another officer, and they change their minds and say, oh no, you're right, there is going to be a finding of a violation of policy. Now we have to come up with a disciplinary decision. So that disciplinary decision flows from the new finding that was made by the appeals panel.
Okay, I see that now. Thank you.
Is there a way to make it clearer? I mean, I so value the way, especially because you're experienced in the world of these hearings, is there a way to make that clearer the way it's written?
I'll think about it, and if I have a suggestion, I'll make it later. But for right now, I was just trying to understand. Thank you.
Thank you. Then can we move on to the next one?
Well, there's only 3 left. Do you think we can do that before we have to take a break?
Sure, let's do that.
Okay. Oh, wonderful. Woohoo. Okay, I'm just getting myself psyched up for it. All right, E3H. Members of the appeals panel shall have the same authority to compel officer testimony and subpoena witnesses or documents as the original hearings, perhaps capitalized panel. And, you know, of course, that goes without saying if they are the same original hearings panel, but I think it's just important to affirm that if there's a separate group of people doing the appeals, they can do these things.
Thank you, Co-Chair Dan. Is there questions or suggestions, comments? No. Because what's only capitalized, can we move on, or I should need to ask for question support?
I think there's been technical changes. So,
Okay.
do you ask already if we're ready to move on?
Yeah. Okay. Thank
Yes. E3I, notifications of the appeal outcomes to complainants and officers shall be the same as under the hearings process C4C, with the exception that no further appeals are allowed through the board.
Thank you. Is there any question or comments about E3I?
No, but for the record, are you able to go back to C4C? Yeah, we put that. The bold text is just something that Co-Chair Michelle Wesley and I put in for clarification. So
Okay.
C4C, following decision of it was there for a second. Following the decision of the board, the findings shall be shared in writing or other means if requested with the complainant. And we're hoping to add officers in there. I don't know if we'll do that when we lap back around. But so that's what C4C says. People who are playing along at home. All right, so let's go back to E3 where we were.
Okay.
Did anybody have any questions about that? So the no further appeals allowed through the board, Commissioner McDowell kind of also gets at, we don't know whether officers' rights to these other kinds of appeals are immutable because some of them are written in law, but they can't go back to the board anymore, right? Okay, I can't move on until our facilitator says so. Thank you, sorry.
Yeah, thank you. No, it's okay. Any additional questions, comments? No. Okay, can we move on? Thank you.
All right, here we go. E3J, the board staff shall schedule appeals in consultation with the board chair or designee. And that is kind of adapted from city code, where the staff was making decisions, but it'd probably be a good idea to make sure that the appropriate people are available at the time that the appeal is being scheduled.
Thank you. Is there a question or comment about E3J? No? Okay, sure.
Yep.
Dr. Moses?
Yeah, staff suggests leadership potentially as a change.
To clarify, it's not a suggestion, it was just a question.
I understand what you're getting at, that we haven't decided if there's going to be a chair, so sure, board leadership or designee is fine.
Okay. Board leadership. Okay. Thank you. Are there additional questions or suggestions? No. Okay, let me ask the question. Is there a strong opposition to changing from as it is to a proposed change? Is there a general agreement to changing from what it was to a proposed change? Great, thank you. We finish E, we can take a break. Congratulations on finish E. This 7:43, we will take a break until 7:50. Thank you. Thank you. We will continue reviewing and discussing the document. I will pass it to the co-chairs.
It is Co-Chair Michelle Wesley's turn.
Okay, you sure you want me to go this time, or would you like to do this one? It's so very long.
F1, no, not that bad.
Okay, all right, hold on. I just had it in front of me.
bring problem down there. The last one says F2 and it's supposed to say F1.
One moment, please. Right. There we go. Okay. F1 is mediation. And there shall be a voluntary mediation program between complainants and officers. F1A, the board has the authority to provide for voluntary mediation between community members and law enforcement. F1A1, goals of mediation include improving police community relations and building better policies. F1A2, the board shall determine whether the case is eligible for mediation based on the nature of the allegations and the officer's history. F1A2, Roman numeral 1, the community member shall be able to consult with their advocate and or their other support persons before making a decision whether to agree to mediation. F1A2, Roman numeral 2, complainants shall not be unduly pressured to choose mediation if they prefer an investigation to take place.
And there's one more.
Yes, one more.
One more? Oh, there it is. F2A2, Roman numeral 3. An officer supervisor must clear them for approval before the officer can agree to mediation.
Thank you, Co-Chair Charlie. I want to ask if there are comments, questions, or any suggestion about F1A. No.
So,
Yes,
yeah, but,
Co-Chair.
before,
Sure.
but you know, just to be clear, the things that are shown in here as strike throughs and bold additions are things that Co-Chair Michelle Wesley and I did between the last draft and now. So since we haven't contemplated before, I'm hoping that we're just going to consider that what was read into the record is what we're voting on, or what moving on past or discussing. And just for the record, the last item was F1A to Roman numeral 3. That was another typo on my part. Thank you.
Thank you. Okay, then if not, then can we move on? Okay, thank you. We can move to the next one.
Okay, that's why I was confused. Okay, thank you. F1B, mediation is not offered for use of force, profiling, legal violations such as improper stop, detention, search, or arrest, or for officers with a pattern of misconduct. No case identified as an automatic investigation by the charter shall be eligible for mediation. F1B1, mediation is offered for discourtesy and procedural complaints, including unwarranted action other than those described in section F1B and neglect of duty. F1B2, if the complainant filed the misconduct complaint based on actions during an incident in which the officer filed criminal charges or citations against the community member, once those criminal allegations have been resolved, mediation about the misconduct complaint can still proceed. F1B3, if there is a civil lawsuit or criminal case against the officer, mediation cannot proceed. F1C, the discussion.
Sorry, Co-Chair Charlie, we're gonna discuss.
F1B.
Yes, please.
Okay.
Thank you. Is there discussion, questions, comments on F1B? Yes, Commissioner Catherine?
It's just a small point, but I wonder if we could say mediation is not offered for complaints involving. So we would be adding is not offered for, and then we'd add complaints involving the use of or involving use of force, profiling, etc.
Okay, thank you. Is there any additional comment? Yes, Co-Chair Dan?
We should probably do that for F1B1 as well, for is offered for.
Okay. Thank you. Then let me ask, is there a strong opposition to changing from as it was to the proposed change? Is there a general agreement to changing from as it was to the proposed change? Thank you. Can we move on?
Okay. F1C, the discussions that take place in the mediation are confidential unless the parties agree otherwise.
Sorry, Co-Chair, yes. Okay, you can continue.
Okay.
Oh, it's only one. Sorry.
Yeah.
Thank you. Is
Like,
there?
what am I missing?
Yes, my mistake. Is there any, sorry, discussion questions about F1C? Can we move on? Okay, let's move to F1D.
F1D, mediation shall be screened and trained properly about power dynamics, cultural awareness, racial bias, and other issues which may underlie the incident.
Thank you, Co-Chair Charlie. Is there a comment, questions? Can we move on to F1E? Okay, let's go to F1E.
F1E, for eligible cases, mediation is an alternative to investigation. F1E1, if either party rejects mediation, the case is sent to investigation. F1E2, either party to the mediation or the mediator can determine that mediation is not successful and ask for an investigation if mediation fails.
Thank you, Co-Chair Charlie. Yes, Commissioner Catherine?
So I think it might be clearer if we put referred to full and preliminary investigation. So we would say mediation is an alternative to full investigation. Again, if the case is sent to full investigation, ask for a full investigation, because in our chart we have, this occurs after the preliminary investigation, but before the full investigation. Thank you.
Thank you, Commissioner Catherine. Any additional comments? No. Is there a strong opposition to changing from as it was to the proposed change? Is there a general agreement to changing from what it was to the proposed change? Thank you. Can we move on to the next one? Okay. Thank you.
My turn again. F2. So this is like who can go to mediation, but it's said in a lot more words than that. Mediation is accessible and open to affected individuals, and in some cases to people other than complainants. And I'm going to read F2A along with that. Mediation includes accommodation for people with disabilities as well as interpreters as needed.
Do you want to read to separate there, Co-Chair Dan?
No, I just want to take, that's the headline in the first subsection. So I just want to see what people thought about those two by themselves.
Okay. Is there any additional comments or questions? No, can we move on? Okay.
Okay, F2B, to accommodate schedules, complainants can provide adequate notice of cancellation as many as 2 separate occasions before mediation is abandoned.
Thank you, Co-Chair Dan. Are there any comments? Can we move on? Okay.
Great. F2C. Mediation is open to complainants as well as the family members of people subjected to alleged police misconduct, even if complainants do not themselves participate. And I think this came from New York, yeah.
Mhm.
Thank you. Yes, Commissioner Catherine?
So how would that work if the complainants don't participate? I mean, it would seem like the family would potentially be able to resolve the case around the complainant. That doesn't feel quite fair to the complainant.
It's a good question, Commissioner McDowell, again. So the intention here, I believe, is that the complainant agree that mediation should happen, but they just don't want to be there. They don't want to have to sit in the same room with the officer.
Okay,
So
I get
maybe
that.
there's a way,
Okay.
maybe there's a way to make that clear.
Mhm.
Is there any way we suggest that we can make it clear? Or I will pass it to Commissioner Debbie.
Oh, I was just gonna suggest that with the complainant's permission or something like that, that they could send a family member instead of themselves.
Oh, thank you. That sounds better, Commissioner Catherine? Okay. Let me ask the question. Is there a strong opposition to changing from as it was to the proposed change? Is there a general agreement to changing from what it was to the proposed change? Good. Can we move on? Great. Let's go to next and the last one of F2.
Well, okay, don't get too excited, but the last one of F2 is the last one from the outline itself. We still have a couple other things to do in this document, and then we have to loop back to the beginning, but we're right near the end here. F2D, upon agreeing to the confidentiality of the mediation, one support person for each of the parties may attend but not engage in the mediation to provide moral support and consult during breaks.
Thank you. Is there additional questions or suggestions about F2D? Okay, oh yes, Commissioner Catherine?
All right, I just, is this like a support person in addition to the advocate? Or is the support person the advocate?
Well, I believe that the intention here was for them to only have one person in there so that we're not crowding this room of this confidential mediation with too many people. So if they want it to be the advocate, they can be the advocate. If they want it to be a family member, if they want it to be another community member, they can do it. And same thing for the police officer.
Then
They
can
choose
we,
the one person.
So I wonder if we should say the community or what are we calling them? The community advocate, the advocate, or other support person for,
Yeah.
Something like that, that indicates that it's one or the other.
Well, one support person for each of the parties may attend.
I'm just saying like the advocate or other, or one's support person. I guess I just, since we talked previously about an advocate and a support person, I just feel like we need to be clear that,
and Commissioner Catherine, Commissioner Christian, and Commissioner Debbie may have a suggestion.
perfect.
Yes, I will pass it to Commissioner Debbie and then Commissioner Christian.
What if you just said, one support person of each party's choosing? Because I don't know if we need to define it. I mean, if they want to bring their kid or their mom or whatever, it just seems like the person isn't allowed to say anything and they're sworn to secrecy. So it's whoever that person feels they need to have there to make them feel comfortable.
Thank you, Commissioner Debbie. Commissioner Christian?
That works for me. My suggestion was more convoluted, so that sounds a lot more simple.
Are you sure you want to share it? That's
Oh,
okay.
I mean, I can if you want, but it's more
Yes,
complicated.
Go ahead.
I was just gonna suggest we could leave it how it is and then add at the end, this could include the advocate or a family member or whatever, but that's like defining it, which is what Debbie said we don't have to do, which I agree. So that makes more sense to me. We can keep it as hers. That sounds great.
Thank you, Commissioner Christian. Okay, is there any other suggestion? No? Then let me ask the question. Is there a strong opposition to changing from as it was to the proposed change? Is there a general agreement to changing from as it was to the proposed change? Great, thank you. We finished with F2. Congratulations.
Very exciting. All right, so we still have another round of this to go before we get this off to the full commission. So that's what Thursday's meeting is going to be for. But we'll get through some of that tonight, maybe. We'll see how things go with this part. So we didn't, co-chair Michelle Wesley, we didn't talk about who was going to do this. Do you want me to just start?
Yes, please.
Okay. So this is items for future consideration that we want to have the city council consider, but we're not sending it to city council right now because first of all, we're a subcommittee. Second of all, it's, you know, this isn't none of these I think are necessary to make the board work per se. The commission can make that decision later, but we just want to pass these forward to the commission so that they don't get forgotten by the end of this process. And if there's anything you want to add, you know, change, modify, et cetera, we can put it in here. But again, this isn't you know, part of the proposed process that we were just discussing. Right. So possible items in the Portland Police Association contract to suggest for renegotiation. In New York, disciplinary options include putting an officer on probation. The PPCOA, that's the Portland Police Commanding Officers Association contract, allows for vacation time or non-fair Labor Standards Act compensation time to be taken away for discipline, but the PPA contract does not. These may be worth adding to the corrective action guide. Comments, thoughts, or questions about that?
Thank you.
I'm trying to open up so I can see everybody.
Yes.
Many people as possible.
Is there any, do you want me to ask a question?
Oh, you go ahead.
Okay. Is there any discussion, questions, or comments about this part? No? Okay. Commissioner Debbie?
Well, it seems like a reasonable suggestion to me that the commanders and the rank and file would get the same, you know, option on this.
Thank you, Commissioner Debbie. Any other comment? Okay. Can we move on? Okay. Go ahead. Co-chair Dan.
Okay, so the next one says, the current PPA contract in section 20.5 says that stipulated discipline, which we have to come back to that. In fact, it should say stipulated findings and discipline, but stipulated discipline can be enacted in cases of use of force where the issue is about report writing, for instance. However, wrote being co-chair Michelle Wesley, if the lack of a report indicates an effort to cover up the force that was used, this should not be allowed.
Thank you.
Is that a convoluted sentence, or does that make sense? Or both?
Mhm. Okay, is there any comments, questions about this section?
Okay. So, and I do want to say that there's when we loop back through the stipulated discipline and findings. Well, it should be stipulated findings and discipline is how it's phrased in the current city code. Stipulated findings and discipline. Okay. Next, this is actually a question, but it says, is it a legal obligation officers have to be interviewed while on duty? That's in PPA contract 61.2.2.1. Community members are not paid to be part of an interview. And we're not necessarily asking for an answer to that right now, but it's just something for the council to think about later.
Thank you. And because this is not exactly a part of the document, I can just go, can we move on?
Yeah, unless people have, want to add to it or change it, but.
Yes.
Or
Commissioner
remove.
Debbie? Thank you. Commissioner Debbie?
So I would just, I think it would be good to check to see if other city employees, when they're involved in disciplinary hearings and procedures, if they do it while they're on the job or if they're required to do it as during their time off. Because I think you want to me, you sort of want to treat your city employees more or less the same way. So that's my only comment on that.
Thank you, Commissioner Debbie. Any additional comment? Okay. Can we move on? Okay.
I apologize. I ripped a piece of paper off my pad and I had my mic unmuted. Okay. Is it a legal obligation? Oh, no. Should mention of conducting interviews in police facilities, which is PPA contract section 61.2.2.2, specify this is only an option when no community member is involved and the complaint investigation is conducted by internal affairs or another city body. And again, we're getting back to what that's going to be called some other time. So the question is, this is a city council, this is a question the city council should mention of those conducting interviews in the police facilities, specify it's only for cases with no community members. Is that something that you all agree that we should pass on to city council through the full commission?
Yes, Commissioner Christian.
Hi, thanks. I just want to clarify. I think I understand this one, but want to make sure. It's basically asking to revisit that little bit in the PPA contract to make sure that it's okay to not have the interviews happen in a police facility, so that because hopefully we'd be able to do it in other spaces so that it's not as intimidating or I have a lot of words I could use, but I'll say intimidating.
Oh, well, this is the officer interviews. But
oh, okay, cool.
But I'm starting to think that this might be an important thing to change before the board goes into effect, so that the board investigators don't have to go into a police precinct to do their interviews of officers. So we might want to flag that one differently, because that will affect, I said this whole section doesn't necessarily affect the board's ability to do its work, but this one could. I think maybe we can highlight that somehow, staff, as potential something to pass on to city council while the commission is still deliberating.
Thank you, Commissioner Christian, and thank you, Co-Chair Dan. Then we go to the next one. Can we move on?
Yeah, and this is another one that is along those same lines. Oh, I didn't wiggle my fingers. I'm ready to move on. We propose that the city renegotiate to make sure the board can address, or at minimum, deadly force incidents. PPA contract 61.2.3 says the parties recognize that IPR, which is the current oversight system, has no authority or responsibility relating to Articles 59, which is about performance evaluations, 61.6, which is about the personnel files, 61.7, which is about deadly force incidents, and 61.8, which is criminal investigations. So a very strict reading of this could be made that the new review board can't do what the charter says and investigate deadly force cases. So I think this is a pretty urgent one. This is something the community was asking the city council to fix when the negotiations were going on over the last couple of years, and it didn't get fixed. So I'd like to flag that as something else to put forward from the commission so the board can do its work.
Thank you, Co-Chair Dan. Any additional comments? No. Can we move on?
I just want to, sorry, I didn't raise my hand first. I just wanted to voice strong support for this one. Thank you for flagging it. That was all. Thank you.
Thank you. Okay, can we move on now? Yeah. Okay. Let's move on. Thank you.
Okay. So that's the end of the PPA recommendations. Then we have one recommendation about the DOJ agreement. And we were talking with staff earlier about this, that when we get our final package to the city council, they have to renegotiate the DOJ agreement to accommodate what the board's going to look like. And just one thing we have flagged for that renegotiation is that be sure the list of ways to communicate to the complainant, which is currently in paragraph 140, includes methods other than mail, email, text, and fax. And this is something Commissioner Oriana Barra was kind of on top of when we're making the list of ways that people can. I think that might be exactly the way the language is written, but I don't know. Anyway, so yeah. I hope
Thank
there's no
you.
huge.
Any
Staff, did you look?
comments? Oh, sorry, go ahead.
I was just wondering if staff, did you look that up in the DOJ agreement? I was trying to punctuate it the same way I thought, but maybe I'm wrong.
We'll double check just a second. But please feel free to carry on in the meantime, Facilitator Victoria.
Thank you. Is there any comments, questions about this point? No, can we move on?
Well, so
Yes, question.
Facilitator Laura, here's my thought, that because this isn't a substantive part about the process that we were asked to describe, and these are just notes that we're passing on to the full commission, we approve this tonight, and then when we finish our second run, as we're approving the full document, just have this already approved. Is that okay for our process? Are there commissioners okay with that? Is my co-chair okay with that?
Okay, then I will ask to approve. Is there a strong opposition to changing from what it was to the proposed changes of these notes? Is there a general agreement to changing from what it was to the proposed changes? Okay, thank you. They're all approved. Let's go, moves to the next one.
And just to clarify, the Oxford comma fix was not, that is in the settlement agreement, but the change of the slash was not, so that's been reverted.
Thank you. Your punctuation gets hung up on that.
Yes.
Thank you, staff. So can you flag that we propose, the second we propose paragraph, but something that we want to send to City Council? And I see a couple of our fellow commissioners are in the audience that weren't here earlier. All right. Future phases. So this part is a little less, this is more like instead of notes to City Council, this notes to our future selves. Like if we jumped into a time machine and saw ourselves in the past, we would want to say, hey, what do you have advice for us in phase 3 for phase 4 and 5? And this is what we have come up with as we're going along. So this is just, you know, I guess it would be good also to hear if you have other things you want to add or change before we pass this on to what's going to be like the very long garden plot for those phases. But I don't want them to be forgotten. So the first item that we identified is that prior to intake, the board should promote the ability to file an allegation, explain with whom and where to file and make where to file a complaint, identify staff and outside support which will be provided to complainants, and describe the timeline for a complaint to be resolved. And this was a commissioner's suggestion about, you know, kind of basically community outreach, making sure that the community understands what happens when you interact with the board.
And Coach Jordan, I'm not gonna ask question because it's just to get into the record unless somebody wants to make a suggestion. Please raise your hand. I don't have to ask any question when you're reading this.
Okay, yeah, well, just for my sake, I'd be, if you can just say, does anybody have anything that want to add?
Okay.
Or that would be great. Great, so next for intake, and again, the bold was just stuff that we fixed up in between drafts. Intake, assigning advocates and navigators to complainants upon intake. Do these assistants come from a city employee pool, community organization, contractors, or other? And you know, we're not deciding that in the phase now. We're just saying what they do. We didn't decide who they are. So that's one of the questions for the next phase.
Thank you. Any questions or suggestions? No? Okay. Go ahead.
For investigations, questions include who should be hired of investigators. The barriers document says if an investigator is former law enforcement, community members may still see them as members of the police department. Further, community members do not differentiate between civilian and sworn members of the PPB. It's confusing, frustrating, and intimidating to discuss your complaint about PPB with a current or former employee of PPB. So that's just something not to forget.
Mhm.
Any
Do you have
comments from
any
any?
comments or suggestions in this part? No. Okay, go ahead, Co-Chair.
The next one is a question, should the board write or at least approve rules set up by the director, and the director's a name I think that's envisioned in the charter. Okay, so IPR, the current system code states, IPR shall adopt, promulgate, amend, and rescind rules and procedures required for the discharge of the director's duties, including policies and procedures for receiving and for processing complaints, conducting investigations, and reporting findings, conclusions, and recommendations. And we added the Citizen Review Committee is supposed to advise on operations according to the city code. So, the question that we're putting forward for the next phase is, can the director just unilaterally make up these rules, or will the board have some role in approving the rules?
Thank you,
Anybody
Co-Chair.
have-
Is there any suggestion or question about this? No? Can we, oh yes, Commissioner Debbie?
Yeah, I like the idea of having the director pass, run these, the, whatever they're called, the rules and everything, be past the board.
Thank you. Can we move on? Yeah, I'm sorry. Let's go, Chair, the next one.
The next one is about mediation. It says, have at least one staff person who's dedicated to mediations part of full time. Portland likely would need far less than 130 mediators used in San Francisco. Consider paid professional mediators rather than volunteers. Again, no to our future selves, but do we have any thoughts about that?
Okay, I think that, yeah, they agree.
Okay, reporting. So that's another thing that's going to be in the next phase. Reports should include information about the allegations made and cases turned over to supervisors for informal resolution. And you may remember we talked about that way back in the intake phase, I think. So that those don't get lost. So that I think we're thinking about reporting on things that get investigated, but those should also be in the reports. That's the proposal. That's just also a note to ourselves. We're not deciding that now because we're not contemplating reports.
Thank you.
Okay.
Any comment, question? No? Then we can go move on. Mhm.
Okay, the next one says to publish an annual report that includes information on the outcomes of complaints, provides clear information, and looks at trends.
Any comments or suggestions? No? Okay.
And I think this is the last one. Reports should include cases in which the final discipline imposed deviates from the board's original proposed discipline, or when discipline falls outside the corrective action guide. And that is a current provision in the city code, or police review board reports.
Any questions or suggestions, comments? No? Thank you. We can move on.
Well, I think moving on means moving back. I mean, how much time do we have, facilitators, before we have to go to public comment?
At least we have 25 minutes.
So, let's see, did we answer the question that Mr. Delgado raised in the chat about, we didn't, no. So the question that got raised in the chat by Mr. Delgado had to do with holding proposed discipline until the appeal window is closed, where we might end up having 60 days, a 60-day delay regardless of what happens. And when we loop back to the stipulated discipline and findings, which is findings and discipline, that question will become clearer. We just, we need to clarify some points about that section. And so we'll be discussing that at the next meeting. I hope that's helpful. And then the other question that was raised had to do with sending stuff back for more investigation. We dealt with that. Okay. And so do we want to invite public comment before we go back to the beginning, or do we want to just go back to the beginning and go through the discussion point?
We need to get back to A and review the whole document if possible. I mean, not the whole, but we can then invite to public comment.
Okay, groovy. Co-Chair Michelle Wesley, what do you want to do for this part? We didn't think we'd get this far, so we didn't discuss it. Oh, you're muted.
You're right, we didn't discuss making it this far, so what do you think? Mhm.
I think what we'll do is let staff find the places that are flagged, and then we'll, you can read the first one since I just did a lot of talking, and then I'll read the second one and so forth. Is that all right?
Sounds good.
Groovy.
Mm.
So we're back at the beginning of A1 again, like Groundhog Day. This week.
This
Looks
week.
appropriate.
Are we going all the way back to part 1?
Well, yeah, we're going back to the discussion points to clarify anything that we had left on the table for discussion.
That will be A2. Which one, where we gonna start?
Just going through real quick, just if you could bear with me. There doesn't appear to be anything on A2 either. I'm trying to figure out, okay. That was already discussed in the actual text. That was already discussed as well.
So while staff is doing that, I want to give everybody a heads up and a warning that at the next meeting, when we're going through these discussion points, one of the things I want to do before we send this on to the full commission is stack up the timelines that the DOJ has created or helped the city create to make sure that the 180 days deadline is met against the process that we have designed here, and see if we can figure out a way to make sure that we're not making things worse instead of better. We want to make a streamlined system, and we want to make sure there's community members involved, but we don't want to make things slow down. So I'm going to try to work on that between now and the next meeting.
Okay, so sorry to interrupt. Is it okay if I go on, facilitator Victoria?
Sure, go ahead.
Yeah, so
What the next one is.
yeah, A1 through A4 had either, there are a couple things that are marked in the comments as flagged for further discussion that were already resolved, but the comment still remains. So the first one that doesn't have a finalized text and still shows it in changes or otherwise comments is under A5. And essentially this A5A paragraph has some proposals and but note that there may be a need to flag for further discussion, and that the agreement so far is just on the conceptual side of it, not necessarily the wording.
So should Co-Chair Michelle Wesley read the whole thing into the record, or is there a specific part that's flagged?
There's a proposal to add a sentence, but that may or may not address the this last sentence here. It may or may not address the flag. It just was also sort of tabled at the same time that the whole conversation hit the 5-minute mark.
Okay, so you want me to read this whole
Yeah, should have answered that part of the question. Yes, thank you.
Please.
A5A? Okay. Yeah, I do have some written notes in here that might help. But anyway, during intake, the complainant shall be informed of any obligations the board may have to report something that is stated to them as part of a complaint. It is important that the board not turn over any admission of civil violations, criminal conduct, or criminal intent unless there is an imminent threat of harm to the complainant or others. And then it says that part of the complaint which could incriminate the complainant will be considered confidential.
Thank you, Co-Chair Charlie. Is there a question, comments, or suggestions for A5A? Yes, Commissioner Catherine, and then Commissioner Debbie.
So I guess my question is the part that of the complaint that could incriminate the complainant that would be considered confidential. That would be confidential vis-a-vis the public, but would, I'm assuming the officer who's the subject of the complaint would have access to that part of the complaint. I guess I'm thinking that the officer would have I think we would have well, I guess I'm assuming that the officer is entitled to see the full complaint against him or her. So I'm assuming therefore that this is just confidential vis-a-vis the rest of the world, but not the officer. So that's the question, and maybe Dan can, it looks like Dan added that language, so maybe he can explain.
Yeah, Co-Chair Dan, can you answer that? And then I will pass to Commissioner Debbie.
Okay, thank you. Yeah, well,
Oh, go ahead, sorry.
the answer to your question is, I understand what you're saying from the terms of discovery, if this was some kind of legal proceeding and not an administrative complaint. But what we're trying to do here is carve it out so that if a person who doesn't fully understand their rights because they're not a lawyer, is interviewed by the board and they say, yeah, me and my friends were in the store and we stole a couple of candy bars, but then the police officer pounded me in the face for no reason at all and threw me to the ground and called me the N-word. Now, the fact that they stole that candy bar is really not relevant to whether the officer threw them to the ground and punched them in the face, right? The behavior, if they engage in some kind of behavior that caused the officer to do it, if they said I called the officer, whatever racial slur, and then that happened, that would be relevant to the complaint. For whether or not they stole the candy bar isn't, and it could get them criminally convicted.
Charged.
We don't want to make the board into an arm of the prosecuting part of the legal proceedings. Make sense to you, Counselor?
Thank you, Co-Chair. I will pass it to Commissioner Debbie.
And so my question was going to be, does anybody know what IPR does now? If somebody comes to them and, oh, you don't know, okay, I just was curious. I was in the middle of robbing a bank and then the police officer came and, kicked me in the shins. So, okay, so we don't know how they handle that. Thanks.
Thank you. Then to the discussion, we have, based on the question of Commissioner Catherine, is there any suggestion that we can add to this sentence that way is more clear?
Yeah, I have one. I think that part of the complaint which can incriminate the complainant in criminal proceedings. Commissioner McDowell's hand is up.
Thank you, Commissioner Catherine.
Yeah, I guess I think that this provision could be subject to criticism that it's not fair to the accused officer if they don't get to see the full complaint. I think that is a pretty a pretty fundamental right that somebody has to see the accusations that are being made against them. And I'm wondering if a way around what the problem that we're trying to solve here is during intake, the complainant shall be informed of any obligations the board has to report something said to them as part of the complaint, and to provide the complaint itself to the officer, the involved officer or whatever. So that it's something that's sort of a different proposition, because we're saying if it's in your complaint, we've got to provide that complaint to the person who's being accused, so that then the person who's making the complaint can, is informed ahead of time that what they say in the complaint has to be provided. And that way, the peripheral information that you're concerned about, Dan, you're informing them that whatever in the complaint is going to be provided to the officer, and presumably they would refrain from volunteering that information. So that's the part that I'm totally comfortable saying that the complaint would be, the last sentence would be considered confidential and non-public, but I think that we run a risk of being accused of having an unfair process if a complaint is filed against somebody and parts of that complaint are withheld from the person who's being accused.
Thank you, Commissioner Catherine. Co-Chair Dan?
Well, this might be something we need just to flag for an attorney's opinion, but my experience for many, many years of counseling people who want to file complaints about the police is they're not thinking about how what they might say is going to incriminate them, that they're thinking about what the officer did to them. And it shouldn't be on their shoulders to make that decision about what they want to say. It would be helpful to have a buffer through the review board where what you're just explaining that you believe is important for the officer to hear is what they think the officer did wrong, not what the complainant has done wrong. And we have seen many times when the few times, I guess, that the police come in to these hearings, that they start turning around and pointing at the community member and say, you did this and you did that. And that's not really what the issue is when we're having these hearings or when you're filing this complaint. The issue is, what did you do, officer, right? So unless it's something that the officer was responding to, that so that's why I kind of gave the example of if the person was, being rude to the officer or called them a name before the officer turned around and did that back to them, that would be relevant, even if it might have some kind of criminal implication. But whether or not they stole a candy bar, I don't think has anything to do with the complaint about what the officer did to them in my example.
Thank you, Co-Chair Dan. Co-Chair Charlie?
I have a question. It does say that part of the complaint which could incriminate the complainant. Have they given information before that does incriminate and result in a charge and an arrest and etc.?
That's related to the question that Commissioner Iona asked, which we don't know. We haven't heard of that happening, but it doesn't mean it doesn't happen.
Thank you. And Co-Chair Charlie, let me pass it to staff and see if he can answer or give us some idea. Staff?
I don't think that I'm able to give any clarity on that particular question. The reason for raising the hand was to note that there was a comment that may have been relevant here to sort of narrow the scope of what may or may not. I think the subcommittee has already discussed to some degree that things that end up in the written record would not be able to be kept confidential from the public or the subject officers of a complaint. That's the comment that's visible right now. And that just may be something that was at least conceived of, not necessarily agreed to by the subcommittee on January 9th. Just wanted to make sure that was flagged as part of this. It might narrow the scope of what's being discussed.
Thank you, staff. Commissioner Catherine?
Well, I think if that's the case, then I think that resolves my concern. If we're considering, we're really talking about that the complaint itself would be provided. We're warning people that the complaint itself will be provided and the complaint will be provided. And what we're talking about is parts of the investigation which reveal immaterial but prejudicial material, then I feel like that's a different level of concern and I don't have the same level of concern about keeping that confidential from the accused officer. Because I feel like that's more common, that the parts of the investigation that would be non-confidential vis-a-vis the officer would be the material parts, not what we're talking about, which is immaterial or irrelevant issues that could potentially incriminate the complainant.
Thank you. Commissioner Catherine, do you want to suggest any change or any, would your comment, or just like that is?
I think we would need to say that part of the investigation or interview in the last sentence would be considered confidential.
Okay.
So does that make sense? Dan is giving me a yes, so I think maybe we'll get to the place perhaps where we were back in early January.
Thank you. And I will pass it to Commissioner Christian.
Hi, thank you. I just want to make sure that I understand. I think it makes sense, but want to say it how I am thinking about it so that I make sure, because I have some of the words I don't fully understand. So let me just say what I'm saying. Tell me if I'm understanding. I understand this as when the complainant is getting interviewed during or making their initial complaint during the intake phase, and they are talking about the incident. If they say something like the candy bar incident that Dan mentions, as long as that doesn't make it into the written record, it can be kept confidential from the police officer. Is that correct?
I think that's what Commissioner McDowell is suggesting, and I
Okay.
didn't realize the word complaint was the hang up on that sentence. I thank you for fixing that. Yes, so I think that is what is being proposed, and I see my co-chair has their hand.
Thank you so much.
Yes. Co-chair Charlie, I'm sorry, I didn't know you were still. Okay, thank you. Okay, then I'm ready to ask the question if I don't have any more suggestions. And what I will ask is there a strong opposition to changing from what it was to the proposed changes? Is there a general agreement to changing from what it was to the proposed changes? Okay, thank you. Can we move on? Okay.
Okay, so the next item is under A5A1. This had a proposal, several proposals to change from what was in the blue text to the red text, or the red shows the changes, and it just hit the time limit that was given by the subcommittee, so it was flagged for further discussion. It had previously said, during intake, staff shall not judge the complainant or their allegations, even if they do not think the complaint is true on their truth or merits. And then the proposed change was to, during intake, staff shall not express opinions about the complainant or the truth or merit of their allegations. And this was a proposal that was neither accepted nor rejected by the subcommittee. So that would be, it's on the table to resolve now.
Thank you, staff. And any questions or suggestions? No, because then I can ask the question. Is there a strong opposition to changing from what it was to the proposed change? Is there a general agreement to changing from what it was to the proposed change? Okay, thank you. Can we move on? Okay.
So the next item is possibly already
Go ahead.
and Co-Chair Dan, if you could clarify that. But I think I have no note saying it was resolved.
Oh, it said, oh, it was?
Possibly, I'm clarifying. So this is A6D. And the question was whether or not it's redundant or possibly confusing if it's close to redundant, but not exactly the same, with a later portion of the document that says the board will investigate even if the officer leaves PPB.
Oh, I see. No, I think my suggestion on this was to leave it in, even if it is redundant. I don't think it hurts to have it in two places and be really explicit about, because we're talking about if an officer leaves the PPB when they're a full-fledged officer and retire or fired or resign, is different from a probationary officer being fired because they haven't been fully whatever accepted as a full-fledged important police officer yet. So I think it's good to have it in here explicitly. And this came from city code. So that's my proposal, is to leave it in. Discuss.
Thank you, Co-Chair. Okay, is there any questions, comments, or discussion about A6D? Okay, can we move on? Okay, let's move on. Yes, Commissioner Christian?
Sorry, was that last motion approved then?
Yes, but do you have a comment or question?
Sorry, no, I just wanted to make sure. I just was curious because I didn't hear the word approved. That was all. Thank you.
Okay, thank you.
Just to clarify, there was no proposed change in the last one. The proposal was to leave it as it was.
Okay, cool. Thank you.
Yeah.
Thank you.
Yes, Co-Chair Dan?
So I'm looking at the clock, and I think once we find all the pieces of A that need to be discussed, I think we should just wrap it up, even if there's not a lot of public comment tonight. I think we would be happy if we get done a little early. I'm looking at my co-chair for approval on that statement. Yes. So yeah, once we get it through all the A's, I think we should just go to the next steps of the agenda. Thanks.
Thank you.
So then there are two items under A. One is the discussion question, and possibly I'll try to show the whole thing here. But this may have been resolved by an item that was discussed later on in the document in part, or is similar to a question that was asked later on in part. But yeah, there was a question of, should the supervisor of an officer be able to decline the informal resolution that is referred to in A8B and send the case back for, I'm guessing, a full investigation?
So this was, my fellow commissioners, this was what I raised as the issue in the flow chart that Commissioner Aiken kind of inadvertently flagged. Right now the board gets to say, okay, well, this is a minor complaint. We don't have a lot of background on this officer, and we think this is okay. If the person, all they want to do is talk to the supervisor, that's fine with us. But then when it gets to the supervisor, if the supervisor says, I don't think so, is that something that we want to let the supervisor, force it back upon the board for a full investigation? Question mark. I guess so bear in mind that just because it gets investigated doesn't mean that anything's going to happen to the officer. Because if it's relatively minor and if it's not true, then it's not like the supervisor is, unduly going after this person because of some personal dispute. It just means they think that they don't want to handle it as an informal discussion with the complainant. They just want to let the board do the investigation so that it follows the normal path. See a couple of hands. Taylor, Laura, will you decide who's going to speak?
Sorry, I was mute. Commissioner Christian?
Thank you. I just wanted to ask, would it be too complicated to give the option of checking in with the person who originally made the complaint in that situation? Because if they wanted to originally talk to the supervisor and they may have an opinion themselves on if they'd wanted to go to a full investigation or not, would they? Maybe I'm misunderstanding. Just let me know if I am, but that's what pops into my head from this query.
Thank you, Commissioner Christian. And before they answer the question or to have suggestions to change, I will pass it to Commissioner David too.
So it seems to me that, people set up employment situations where you have supervisors who are supposed to use their judgment in supervising the people who serve under them. If the supervisor thinks that this needs to be taken care of through the normal channels, then I think we should respect that and let them make the call. I also think about how we hear the compliance officer talking and the DOJ talking about how the city isn't really using making the best use of its EIS system, the employee information system, to kind of intervene sort of early on in with officers and their, how they practice their profession. And so, I think this is one way of giving supervisors that kind of responsibility.
Thank you, Commissioner Debbie. Co-Chair Dan?
So here's my proposal to incorporate these ideas. So A8B, I would like to end that at the end of whether such resolution is appropriate. Then put a carriage return there before once approved. Say A8B subsection or A8B1, right? The supervisor shall make a determination whether to resolve the case informally or send it back to the board for investigation. And A8B3 would be once approved, the case can be resolved this way without, no, I want to leave that word verbiage in there. Once approved, the case can be resolved this way without formal investigation, and the complainant will be informed of this decision. Well, and the complainant will be, I guess A8B3, oh no, sorry. A8B3, yes. A8B3, if the case is sent on for full investigation, the complainant shall be informed. And I'm saying that because I think that they've already stated that this is what they want to happen. The system itself has decided, no, that's not what's going to happen, and we're just going to let you know we're going to do an investigation. We'll get back to you. That work with your concern, Commissioner Oriana Bauer?
Yeah, that works for me. They could, because they could also have the option to withdraw their complaint if they really didn't want to send it through to investigation, correct? Yeah, okay, cool. Yeah, that should be fine. I just wanted to make sure they had the option to have a say in the matter if that was the case, if it was rejected from their original hope. Thank you.
Thank you, Commissioner Christian. Then I will ask the question. Is there a strong opposition to changing from what it was to the proposed change? Is there a general agreement to changing from what it was to the proposed change? Yay. I think we only have to review one more thing on A and then we finished, right? Oh, this was, yes, one more thing. And then we continue with the agenda.
Correct. So this is A9B. This relates to the dismissal of a complaint after a preliminary investigation prior to a full investigation happening. And it's under A9B, which is the reasons for potential dismissal of a complaint. And it was A9B4. The text read, it still reads at present, applying an objective standard. The complaint is trivial, frivolous, or not made in good faith. And there was a proposal to add applying an objective standard. The subcommittee approved that, but there was a continued discussion and therefore was flagged to circle back to now.
Yeah, I have a suggestion. Let's make this the first thing we talk about on Thursday, because I don't think we're going to resolve this easily. But I would like people to do some homework and think about better words, better verbiage for this piece. Because I know my co-chair, Michelle Wesley, was very concerned about those words, trivial, frivolous, not made in good faith. Those are pulled from the current code. But if anybody has suggestions between now and Thursday, let's do that. But I think we should hang up our hats for the night and be happy we got as far as we did.
Yes, and co-chair, before I need to ask if anybody at this moment has any comments to this. Because was already read, and we can discuss it later. But if somebody has any comment or suggestions right now, we should put it there too. No comments, no suggestions. Okay, perfect. Then we can, congratulations, you advanced a lot. Great work, commissioners. Okay, let's go to the next item and the agenda. And it will be public comment. Okay, yes. Okay, let's go to public comment. And I don't have it here, but okay. Okay, I will just say that now is time for public comment. Co-chair Charlie, oh, you're gonna read an email before public comment? Go ahead.
No, I want them to be able to go first and then I'll read this into.
Okay. Perfect, thank you. Staff?
Yeah, just to clarify, the agenda actually has next steps followed by public comment for today.
Okay, then let's go to next steps.
Yeah, I'll make this very brief to not take time away from those who are in the audience. This subcommittee is going to meet one more time this coming Thursday. The meeting may run long. In between now and then, members are asked, as Co-Chair Dan mentioned, for this last item, just for everything that's marked in the document you'll receive as flagged for further discussion, or anything else, to give any input they may have and track changes. That'll essentially be pre-received proposals for text changes, and the subcommittee will work through the flags for further discussion and anything that you submit and track changes on Thursday. And eventually, hopefully, be able to refer the document to the full commission on Thursday. The full commission, as you know, is meeting next, has 2 meetings scheduled next Monday and next Thursday. Additionally, kind of behind the scenes, staff will be combining the documents into a single document and working on implementing the footnoting and references and other formatting changes, like renumbering that 13.5, for example, by Thursday as well. And that's all I had. So I'll pass it over back to general public comment.
Thank you. We're going to hear from the public. Then we ask members of the public to keep their comments to 2 minutes in length and keep their comments focused on what was discussed today and the draft document. You can raise your hand in Zoom when you like to be called on. I don't think.
I
I
don't
don't-
see anything.
Go ahead. Go ahead, Dr. Moses.
Yeah, I don't see anyone raising their hands.
Thank you.
Mhm.
Okay, let's go to Co-Chair Charlie.
I'm trying to determine which one of these to read. Well, okay, I'll just read the first one. It was dated 1/26. I didn't get a chance to read it, so I'll read it into the record now. Okay, so it's from Mark Poise, POIS. Hello, commissioners. Thank you for your work on the commission. I watched the Dan Ryan and Aaron Schmutz meeting, and when Commissioner Ryan asked if you do this once a week or is it every other week, I realized that he had absolutely no idea how much work you all are doing. Thank you. On to my comments, which I'm specifically specifying as being related to PAC community engagement events, including town halls with specific partner groups and general listening sessions on the web form, but which I would like to make sure all members get a chance to read. I initially sent this to the commission staff email address, but want to make sure it gets on the public record and that all of you are able to read it. Here is some feedback on the last in-person listening session, which I listened to thanks to the MP3 audio that Austin sent me. The audio is hard to hear at times, and it is often nearly impossible to know who is speaking. I appreciate that there were 4 listening devices. However, it might be necessary to either have more listening devices or better ones in order to capture clear audio. For future sessions that are recorded, please consider also recording video. I understand that there are community members who might not want to be filmed, so it might be best to have the cameras away, always facing the commission members so the community can see the impact that people's testimony is having on them. For community members who want to provide feedback but not have their voice recorded due to being afraid of retaliation from police, there should be a safe and secure way for those people to provide feedback to the commission without fear of retaliation. Oops. I understand that giving community members the opportunity to meet the commissioners in person is incredibly valuable, since we are also still in a situation where many of us are unable to meet in person due to the potential of catching COVID-19. The commission and the community would be best served by having these in-person meetings changed to hybrid meetings so more people can participate, both commissioners and community members. It's important for every commission and staff member to hear the community members who is speaking at, I don't understand what this is, 1:16:39 say, I'm just appointed in the commission right now because if there are 20 of you in this commission and there are less than half of you here in attendance to hear the people that are in this space, how can we have any faith, unintelligible, that you're actually going to be fighting for the accountability of this institution that has caused egregious harm in this community? From following the commission's work, I have seen just how committed the commission members are to their work. I suspect that had a hybrid option been chosen for this meeting, nearly every commissioner would have been present.
Co-Chair Charlie, I'm sorry to interrupt, but we have to keep at the meeting, and I saw somebody raise their hand after when you started, and I want to pass it to the person to do
Okay.
a public comments. And because the time, I'm sorry, I need to cut it off.
Mm.
Okay, I will now pass it for a public comment to the person who raised its hand. Yes, go ahead, Mr. Tim Larson, you can start.
Thank you. I thought the questions would be read, but since it didn't come, my comment didn't come up. The question I had was, since the parties can agree to confidentiality in the hearing, and given the lack of veracity in so much of our culture now, is it really a good idea to allow an emotional support person to attend either with the complainant or with the officer? The chances of them talking out of school is going to be significant. So that's my question.
Thank you, Mr. Larson. We appreciate your comment. And because the time, I don't know if staff should they answer, or just because he was able to comment, he was, yeah, please tell me.
Up to you. I think that is the section that was being screen shared. This relates to F2D. F as in Frank to D as in dog. So maybe up to commissioners whether to address now or when circling back to this, because that is something that the commission will circle back to next meeting, as it's very close to the end of the document on Thursday.
Thank you. Yeah, I will, if we can keep it brief and then also review for next time, Co-Chair Dan, I will pass it to you.
Well, I just want to say I appreciate Mr. Larson's comment, and I didn't see it in the Q&A before. It's apparently there was a response from the staff, so we'll take it under advisement for the next meeting. Thank you.
Thank you very much. And again, Mr. Larson, thank you very much for being here and for your question. We really appreciate it. Then we're gonna move on because the time we're gonna move on to the garden plot recap. And before I wanna remind everyone, this is a time for facilitators, co-chairs, and staff to summarize any items already brought up today, which didn't fit into today's agenda. We'll recap those items here and use them in developing future agendas. We won't be using this time to add new items not previously mentioned or to discuss any items, but we will use this list to develop future agendas so these items can be addressed. I will pass it first to the co-chairs. Is there anything that you want to add to the garden plot? Okay.
Yes, sorry. Well, we didn't have time to talk about it so far in this meeting, but today we spent, co-chair Michelle Wesley and I spent some time talking with Yume Delgado, the co-chair of the CRC, about the police review board process and what parts of it might be changed to improve it. So we're going to try to work that into the next pass through as we think about what he said to us, and I'll try to type up a recap of that and send it around tomorrow. So that's a garden plot item. And then we also are hopefully going to be speaking with Jared Hager from the DOJ about the question about stipulated discipline. So that will also hopefully come up on Thursday. And just to reiterate that the staff has started a draft of what the newly formatted document will look like. So Co-Chair Michelle Wesley and I will look at that tomorrow. And there's a co-chairs meeting tomorrow before the Q&A session that's, the public is invited to. But we'll have time to approve that so that staff can get that all reformatted and looking lovely for you before Thursday's meeting. Thank you.
Thank you, Co-Chair Dan. I now will pass it to Dr. Moses.
No additional garden plot items here.
Thank
you. To staff.
Okay, thank you very much, Dr. Moses. Staff?
Yeah, so there's two categories here. There's that last section, which was essentially a section to put into the garden plot, all the items to potentially suggest to the city council for PPA negotiations, as well as the DOJ agreement amendments process that they'll be doing as part of the approval process for the PAC's recommendations. I'm sorry, that's not the part. It's the part after that. It's the future phases portion, which is the very last part. Apologies there. So all the prior to intake investigations, all those items are essentially garden plot for the next phase of work. And then there are two items which are flagged in comments as to ask for attorney guidance. And those items would be ideally resolved prior to the conclusion of this phase of work, but the content of that it's not for today, so or it has not been received yet. So those are the two categories of items, and those are in the comments or in the document in some way already, so you can see them all written down already. Thank you.
Thank you. Now, as a reminder, you can now submit advanced public comment to the Police Accountability Commission via web form, voicemail, and postal mail. Thank you to all the members, the commissioners, and the co-chairs who attended today's meeting and for the contribution and hard work today. Thank you also to the interpreters. Finally, thank you to all members of the community for attending and contributing your thoughts and questions. If you are not already signed up for email updates, please also sign up to receive updates from the PAC. It's now 9:10 p.m. and this meeting is adjourned. Thank you very much. Thank you.